Hi, everyone. I'm Maggie McGrath, senior editor at Forbes. On Monday, April 14th, the Liberty Justice Center filed a lawsuit challenging President Trump's tariffs, saying that the emergency measures that he hinged them on are not legal. Joining us to discuss the merits of this case plus two similar cases is Daniel Wolff. He is a partner at Crowell. Dan, thanks so much for being here.
Happy to be here. Thanks for having me.
So I mentioned this Liberty Justice Center suit, which we saw come down on Monday, but before you and I started recording, you mentioned there are two similar suits. They all kind of center around the argument that the Trump administration used to institute these tariffs. They say, this lawsuit from the Liberty Justice Center say that the president's justification, quote, does not meet the standards set forth in the International Emergency Economic Powers Act. Let's start with this Liberty Justice Center suit. What do you make of the arguments from the plaintiffs?
Well, you're right that there's three suits, and this suit, like the other two, basically make the point. There's really two key arguments. One is that the statute you just referenced, which is commonly referred to as IEPA, doesn't, by its own terms, authorize the tariffs that the president has set and has, tweaked over the last few days. And then the second argument is that, as a matter of constitutional law, he can't do this because the setting of tariffs is vested with the Congress of the United States, and it's not an action. It's not something that the Congress can delegate to the president. So even if IEPA purports to give the president the authority that the president is claiming, that would be unconstitutional.
That would be unconstitutional. So based on that sentence that you just said right there, does this mean that these suits, any one of these three, could go up to the Supreme Court?
Well, yeah, any of them could, any single one of them in combination, or I would anticipate there will be more suits. And so I would think that this question of the president's tariff setting authority, given the magnitude of the economic impact and the gravity of the moment, I think one or more of these cases could percolate up to the Supreme Court.
Now, the case from the Liberty Justice Center was filed in the U.S. Court of International Trade. And this may be a nitty-gritty procedural question, but does it matter where these lawsuits are filed? And then does that affect the possibility of getting to the Supreme Court?
Well, on the first part of that question, the answer is a strong yeah, probably. And I know that's very lawyerly, but Congress has the authority to channel. So we have our normal Article 3 district courts, but then we also have specific courts that have been created by Congress to serve specific functions. And the Court of International Trade is, as its name implies, the court created by Congress as an Article 3 court to adjudicate, a whole host of trade matters. And the answer to your question matters because if you're in the wrong place, you may ultimately get to the Supreme Court or even, Intermediate Court of Appeals and get dismissed because procedurally you filed in the wrong place. So it is important, and I think that, I will be watching certainly how this is playing out. In general, whether a case starts in a traditional district court, federal district court, or the Court of International Trade, I don't think that by itself, certainly there's nothing prevents a case starting anywhere from rising up to the Supreme Court. I think the bigger question is the first half of your question, which is what is the correct form? And I'll just note that the first case filed, which was in federal district court in Florida, just yesterday, the government moved to transfer that case to the Court of International Trade. So already signaling that the government itself thinks that yesterday's filing was in the right place and that the other two that are in federal district court are in the wrong place.
That's interesting because these are basically small businesses in their local jurisdictions filing suit because of, I'm summarizing here, but severe financial impact from these tariffs. So does it make sense that they filed in their local jurisdiction, or are all of these, is it better if the U.S. Court of International Trade is the primary vessel?
Well, again, you have to go to where Congress tells you to go. And so, the courts aren't going to be sympathetic to the position that, well, it's more convenient for me to file in the local court if Congress has directed these cases to a specific court like the Court of International Trade. And the answer to the question of where this is supposed to go kind of depends on which of the two legal issues that I articulated at the outset control the outcome of this case. If it's a purely statutory claim, i.e., IEPA doesn't authorize this, and so the president doesn't have this authority under the statute, I think federal district court might be the right place to hear that case, because the Court of International Trade is, among other things, directed to hear cases that challenge issues that arise under statutes that provide for, among other things, the setting of tariffs. So if the answer to the statutory question is IEPA doesn't provide for, then federal district court seems to be the right place. If you read IEPA to provide for tariffs, and then the only question is whether it's constitutional or not, then it seems to be that the Court of International Trade is the right place. So I know that you mentioned that it seems like a procedural issue, but it's an important issue, and it may actually depend on which claim is the one that resonates most with the court.
Well, of course, the procedural issues affect everything else. It's a ripple effect. And in looking at this suit that was filed yesterday from the Liberty Justice Center, I'm looking at a quote that I would love to get your take on. The filing says, quote, "The president's justification does not meet the standards set forth in IEPA. His claimed emergency is a figment of his own imagination. Trade deficits, which have persisted for decades without causing economic harm, are not an emergency." Dan, what do you make of that part of yesterday's suit?
Well, I mean, it's from as a matter of common sense, I get it, and it's a rational argument to make. I would say, though, that debating with the president over whether there's a national emergency or not is really a distraction from which is not to say it's not a meritorious argument, but I don't think it goes to the ultimate issue of the president's legal authority, because we can debate whether there's a national emergency, and I take the point from this set of plaintiffs to be that it's all pretextual. There really is no national emergency, at least one that's cognizable under IEPA, and that this is just sort of a setup to try to impose a tariff regime to further the policy objectives of this administration, but it's not anchored to the statute itself. We can debate that, and it's a fair debate, but ultimately it doesn't answer the question of whether the president can do this or not. It does go to whether the statute authorizes this and in this particular way. But the constitutional question at the end of the day remains, even if the president has checked the boxes for determining a national emergency, does he have that separate and, I would say, standalone authority to set tariffs? And that, to me, is the harder position for this for this administration to justify is to say that it can actually, whatever it says about national emergency, it can set tariffs as it has done, both dating to the February executive orders and then more recently in the April executive orders.
I see. So there are really two questions here. Can the administration do this under emergency measures? And then what is the administration legally and constitutionally able to do under normal circumstances?
Yeah, and just to punctuate what I just said is we could even and I'm not stipulating, but I'm just saying, if one were to stipulate for the sake of argument that there is a national emergency, that still, in my view, as a matter of constitutional law, doesn't justify the tariffs that have been set. And so I think however you slice the salami here, this lawsuit is a strong one. And if they don't prevail on the statutory question, they should prevail on the constitutional question.
Well, given the number of lawsuits we've seen just over the last week, I'm wondering, this is a crystal ball question, but do you think we'll see more?
I do. I do, just given the economics of the moment. I don't think I think we're starting to see the cracks in the dam. We had, the first lawsuit was filed early last week. Now we had another one, the district court in Montana, brought by several members of an Indian tribe, and now we have this one that was filed yesterday, and I don't see any reason to think that we'll stop with three.
And does the court care about the economic hardship that some of these businesses are already facing? I think what I'm getting at is a timing question here. For a lot of small business owners that we've been speaking to at Forbes, it feels like an immediate existential question. They're already facing higher costs to import their goods, so they need help now. What I'm wondering is, does that emergency on behalf of the small business owners affect the way any of these courts will proceed?
Well, it could, to the extent that the parties are seeking either preliminary injunctive relief or expedited review. And I'll note that neither the first case filed in the district court in Florida nor the one filed yesterday, at least as of last evening when I last checked the docket, had moved for a preliminary injunction. And we see a lot of the other challenges to executive actions over the last couple months involve motions for temporary restraining orders and preliminary injunctions. That's the mechanism to move a case along. That's the mechanism by which plaintiffs state, if we don't get relief immediately, we will suffer irreparable harm. The only case of the three that we've talked about here that has filed a motion, the only set of plaintiffs of the three that we've talked about here challenging the IEPA tariffs that has moved for a preliminary injunction is the one in district court, out in the district court of Montana, which I think is itself interesting. Now, in terms of whether the harm to the small businesses as a general matter heightens the importance of this matter as generally speaking, I don't think that. I think that the tariff setting authority under IEPA and the magnitude of it by itself is going to be the more compelling reason to elevate these cases, possibly up to the Supreme Court. I think it's just a very important legal question or set of legal questions. The sympathetic plaintiff, that you see that in a lot of cases. So I don't know if that by itself, certainly when you get to the Supreme Court and they tell the narrative of the story, and we've seen this in any number of cases, that small plaintiff narrative, sort of under attack by the federal government, that plays into that. There's a sympathetic fact, there's a sympathy factor, but it's going to be the legal question that I think drives these cases.
Of course. One of the small businesses within yesterday's suit that went to the International Court of Trade mentioned TerryCycling has already paid $25,000 in unplanned tariffs this year. They project $250,000 in extra costs by the end of 2025 and $1.2 million in 2026. So that's a lot for a small business. Yeah. So they're definitely making the sympathetic case. I want to go back to what you said about that Montana filing. You said there was an injunction there, and that was interesting. What makes that case interesting to you?
Well, there's not an injunction. What I said is they filed a motion to get a preliminary injunction. The court hasn't. I think the court. The last I checked the docket, I think the court asked for a response by May 1.
Okay, sorry, I misinterpreted that. So response by May 1, it is April 15th, tax day today. What are the next steps, and how fast do you expect this to proceed? Because we've already seen over the last 2 weeks, day by day, changes to the tariff policy, the tit for tat with China. It feels like the ground is shifting beneath our feet on the economic policy side. What are the next steps on the legal side here?
Well, I think the jurisdictional question, the venue question, is going to have to be worked out, and I think that the motion to transfer in the Florida case will draw a response from the plaintiffs. I've already read some media reports from counsel in that case defending their choice of venue, so I think they will oppose the government's motion to transfer. And I think that you'll see an argument in opposition that echoes what I said a few minutes ago, which is that if the only question is whether the IEPA authorizes the president to do this, then that's properly brought in federal district court, and the Florida venue is perfectly fine because that's where the small business plaintiff is down there. In terms of the merits, I'm going to check the CIT docket in the case brought by the 5 small businesses yesterday. Again, I didn't see them file for a preliminary injunction. I think that's probably because they have the right to seek damages from the Court of International Trade, and typically, if you can collect on the back end, you don't really have a reason to get preliminary relief, because if you're right on the question of law, you'll be made whole at the end when you get your damages. So that's
Oh,
why we probably won't see a preliminary injunction action in the case filed yesterday.
that's interesting. So if the plaintiffs from yesterday prove successful, they will get compensation at the
Yeah,
end.
anything paid to the government, based on these unlawful tariffs, if they prevail on that question, they would get that back.
And here's another if question, but again, with the tariff policy kind of changing week by week,
Yeah.
if the administration were to say, okay, this damage has been too great to our small businesses, to the market, et cetera, we're going to undo everything we've announced since Liberation Day. Would these suits go away, or would that weaken any of the cases? Or because one of the questions being considered is the specifics of IEPA, would they still proceed?
Well, there's a lot packed into that question. Certainly, if the government stands down and rescinds the IEPA-based tariffs, it would go a long way. It would certainly moot out any forward-looking complaint. Whether it moots the existing complaints depends on whether they also provide, whether they refund whatever tariffs have already been paid. And if they do that, then yes, I would expect the government to invoke the mootness doctrine that says, no harm anymore, so there's no reason for the court to get involved. And that wouldn't be, as a general matter, putting aside this particular administration, that wouldn't be unheard of, right? Government reconsiders actions all the time. But, time will tell whether this administration is going to reconsider its IEPA authority to set tariffs. So it really depends on what actions the government takes, how far back they rescind their actions.
It's highly hypothetical, and
Highly
perhaps
hypothetical.
perhaps unlikely. One more prediction question for you. If the Supreme Court were to hear any one of these 3 cases tomorrow, how would you expect the nation's highest court to rule?
Well, good question, because this really brings to bear 2 different questions of administrative law that, at least typically, one would think this administration, being a conservative administration, is on the same side as the Supreme Court. But here they're not. And those 2 issues are deference to executive branch interpretations of statutes, which, now famously, we know from last year's decision in Loper-Bright overruling Chevron deference. Arguably, well, I wouldn't even say arguably, I would say doctrinally, the interpretation of IEPA is not one on which the court should defer to this administration. So that's a pure question of statutory interpretation, and as the Loper-Bright court articulated, that authority to interpret is vested entirely with the courts. So I would think, and so on that statutory question, I agree with the plaintiffs in these cases. There's nothing in IEPA that says anything about tariff setting authority. And it's also economically an extraordinary step that the administration has taken. We might think of it as a major question under the major questions doctrine. So I think, those administrative law concepts that have garnered a lot of attention in recent years, I think cut against the White House. And then the second thing that cuts against the White House is the question of unconstitutional delegations of authority. I think that it's crystal clear that Article 1 of the Constitution vests with the Congress the authority to set tariffs. And there's no guardrails in IEPA that would even provide, what we think of as an intelligible principle under the existing non-delegation doctrine case law. That's what courts look for. Is there anything has Congress put in guardrails to at least you know control what the president, how the extent to which the president exercises authority that is delegated? So even if we assume they've delegated something in IEPA, there's no guardrails here. So I think this administration's IEPA tariffs fail under the intelligible principle theory. And I think, even the intelligible principle as a theory of non-delegation doctrine is sort of, on the wane. And so point being, I think this White House is going to have trouble defending its actions, both on the statutory interpretation question and on the constitutional delegation question. So I think to your question, if the court were to hear that, if the Supreme Court were to hear this case tomorrow, I would favor the plaintiffs in the outcome.
I was just about to say the small business plaintiffs sound like they have the stronger case here, which leads me to my last question, perhaps some free legal advice for the small businesses watching, because of course Forbes reaches a lot of founders and small business owners. What would you say to a founder or business owner who's watching this, is feeling the impact of tariffs and considering legal action themselves?
Well, look, it's not my role to tell people to sue, but I think there are strong legal issues. And I think that if you have been damaged, if you've been harmed by these tariffs, or if you anticipate being harmed, then by all means, we have a legal system that exists to protect the interests of folks, who are being harmed by government action, and the courts are open. And people like me are also available to consult, because these are important questions, and people should feel emboldened to exercise their rights and not sit on their rights.
Very important questions. Dan Wolff, thank you so much for your answers today. We appreciate your time and your analysis of the legal situation as it stands right now. We will have to have you back as these cases proceed through the courts. But in the meantime, thank you so much.
Happy to come back anytime. Thank you.